Our next session is on contract performance, answers to difficult questions. Our panel of experts on GPC and GAFTA will provide interpretation of GPC Contract 1 and GAFTA 126 Arbitration Rules. I'd like to welcome the panel on stage, Andrew Jacobs, Jaine, Chisholm, Caunt, and Huseyin, Arslan.
Can we have the pointer, please? If you can pull the presentation up, please. So good afternoon, everybody. This session, difficult questions on contract performance. We reached out before the convention and asked for some tough questions on contract performance so we could go through with you how the interpretation would be under GPC contract number 1 as well as at GAFTA arbitration. So during this presentation we'll be covering changes in import or export duties, taxes and levies, shipping or quality irregularities, GAFTA arbitration process and its enforceability, and what GPC can do in disciplinary actions against defaulters. I'd like to thank Jaine, Chisholm, Caunt, the Director General of GAFTA, for joining our panel. And we'll start off with the first question, which I will ask Huseyin to address. Is it force majeure if the importer's government changes or introduces duties, taxes or levies? And this could equally well apply if the exporter's government changed duties, taxes or levies. So Huseyin.
Yeah, this is reply is very simple. You know what is the reply? Sorry? Yes or no? Reply, you know the reply means you know the reply yes, or the answer is no? Okay, the answer is, as you can expect, is no, because in GAFTA contract, clause number 13, it is clearly states, you can read from the behind, and this is actually is taken from the GAFTA contract, which is our industry is using it. So this kind of changes is not affecting this reply. The answer is no. Of course, always that provided both parties agree, they are at liberty to explicitly change any standard condition. So the GPC contract number 1, we always say, as in case of the GAFTA, it's a template contract, which means it's a format that having the conditions. So any conditions that you don't like, if you think that you are exporting to Sri Lanka and new government is going to change it, you can say that, okay, this is my condition. If your seller accepts, of course, this can be managed between the buyer and seller.
I would also invite Jaine to comment on GAFTA's experience with claims of force majeure.
It's quite common for people to advance claims of force majeure within GAFTA arbitration. Picking up on what Huseyin said, I think it's important to see the difference between changes in import or export duties and actual prohibition of export. In terms of being able to rely on a claim of force majeure under a GAFTA contract, you need to be able to prove prevention of shipment and prevention of delivery. And this is where most claims tend to struggle. It's often possible to identify something that can be force majeure, but has it actually prevented you from performing the contract? And certainly within the last 4 years that I've been at GAFTA, I'm not aware of any successful claims for force majeure.
Thank you, Jaine.
In addition to that, as Jaine also underlined, and she said one thing, exporting countries impose of duty. we are very much concentrated on the import duties, but there are sometimes countries that imposing the export duty, like in Russia, they imposed an export duty on sunflower, and this happened in several times in the past in some countries. So these are also, so as we always explain, we have to be even-handed. The export imposement, also import imposement of tax or levies are clearly mentioned in the contracts.
Thank you. So what right does a buyer have if they've contracted basis shipped quality and they're disappointed by the arrival quality? If the seller provides a quality certificate which is independent, then the buyer has no contractual right of regrading. However, both GPC and GAFTA in GAFTA 88 realize that it's often impossible for inspectors to get to plants which are sometimes many thousands of kilometers from the port of loading. And where a certificate is based on a submitted sample, or where the certificate of quality doesn't tie up with the goods that are shipped, then the buyers do have the right of regrading. They have to follow Clause 5, lines 30 to 39, which, as you can see on the screen, says, buyers have the option to instruct their representatives to draw and seal delivery samples within 3 business days of unstuffing of the container for the purposes of regrading and/or analysis. And the seller's representative has the right to be in attendance at the sampling. So in such a case, both buyers and sellers in GPC contract number 1 agree to accept the result of regrading or analysis. So Huseyin, would you take this next one? What right does the seller have to claim extension of shipment, for example, if the shipping line fails to load their cargo on time?
Yeah, I mean, Andrew, before coming to this, I think we should explain about this quality certificate and being independent. I think this is here we are a bit different than GAFTA contract, because here we independent means in Canada's shippers, they are delivering the sample of their own. GPC contract is not taking this as an independent, so I underline this. Unless otherwise stated in your contract. So from the seller side, you better emphasize this point. Seller should bring independent certificate. They cannot make their own sample to be tested. That doesn't make it independent. So I want to underline this point very well. Is it clear enough?
That's fine.
Andrew. So if we go to the extension, this is also a bit different, slightly different than the GAFTA contract. You know, as per our contract, we have 8 days granted while we are taken from the shippers, sample submitted. We consider it as independent, but we also introduced 8 days free period that shipper or let's say exporter seller can ask it, or it is in the contract, it is stated. So after that 8 days, they have to ask extra days with certain discounts, as stated also in GAFTA contract. So our contracts, whatever the irrespective of the shipment period, GPC contract allows 8 days. Why we do this? Because you are there, the shippers are loading from the origins, and then it travels at least 5,000, let's say, take this example of Canada, it's traveling 5,000 kilometers. And they are not sure their container is loaded or not on the vessel. Sometimes shipping line is informing very late after when they pass the shipping period. So we wanted to be fair on this, so we added this clause. Thank you.
So when is a notice of shipment out of time, and when is a notice of shipment invalid? So again, we're referring to GPC contract number 1, clause 11, and a notice of shipment has to be passed within 5 days of the bill of lading date. And if there is a string of subsequent sellers, then it's required to pass on the notice on the same day as the person in the string receives the notice. And if you receive the notice after 4 o'clock, then it can be the next business day. And importantly, a notice that is passed to an intervening broker is considered as a notice served on the buyer. And a notice of shipment is invalid if it is out of time, i.e. passed late, or the bill of lading date is outside the contract period. And another important thing to bear in mind is that once you've given a notice of shipment, you can't withdraw it and replace it unless the buyer's consent. So your first passing of the notice of shipment had better be accurate. Otherwise, the buyer, if they consider it invalid, can refuse to allow you to retender. So what are the relevant obligations of buyers and sellers if the shipping documents are delayed and not presented by the time the vessel arrives? It's the responsibility of the seller to get the documents in time, but sometimes they're inevitably delayed. And in those cases, the seller needs to hold the buyer harmless from any justified extra charges that arise due to the late presentation. But to be even-handed, the buyers also have an obligation to mitigate extra charges. So if the buyers can arrange to land and clear cargo by providing bank indemnities acceptable to either the shipping lines or the authorities, then such reasonably incurred costs should be refunded by the sellers.
So this is not a reason for default? Is this a reason for the buyer to not to execute the contract?
No. The buyers are obliged to take up the documents if the goods are shipped on time. It becomes a question of how do you deal with the extra expenses. Jaine, would you like to add anything on that in terms of GAFTA's interpretation?
In terms of reasonable expenses, as long as you can show that they have justifiably flown from the breach, then you should be able to recover those.
But you agree it's not a reason to refuse documents
No.
if the documents turned up late?
No.
So it is an excuse for extra charges?
Justifiable extra charges should be refunded. It's the seller's responsibility to get documents in time. If the documents are presented after the vessel has arrived, they're normally referred to as stale documents.
Okay.
So must sellers insure cargo for 102% or 110% of invoice value? GPC contract follows GAFTA contracts that the seller should provide insurance for not less than 2% over the invoice value. But it's become very common for buyers to request 110% of invoice value, and as long as that is agreed between buyers and sellers prior to shipment, then that can be incorporated in the contract. Where should an insurance claim be payable? Well, best practice is that the claim should be payable in the country of the shipment of discharge. It is important that the insurance certificate be expressed in the currency of the contract, and it's the seller's responsibility to insure with a first-class insurance company which accepts domicile in the UK in case of legal proceedings. It is not, however, the seller's responsibility to guarantee the solvency of the insurance company. And that is meant to be addressed by the choice of what we consider to be first-class underwriters. Jaine, have you got any experience of how first-class underwriters are established?
Usually it's one, as you say, that has a domicile in England to actually receive documents. There isn't a standard definition.
Okay, thank you. If the seller's insurance certificate contains a deductible, is that acceptable to be tendered? Well, we go back to the previous definition that the certificate should be for not less than 2% above the invoice amount. And so a policy with a deductible is not strictly tenderable. However, buyers would be well advised to seek agreement with the sellers that they hold them harmless. And so if there's a deductible of, say, $500 or $1,000 from the claim, that the buyer should say to the seller, you will be responsible if there is an insurance claim to make good the deductible. Because the benefit of having a deductible goes to the seller by means of a reduced premium. So it's only reasonable that the seller should make good any deductible. What's the difference between arbitrating using GAFTA Rules 125, on which GAFTA 88 was based, and on Rules 126 on the basis of GPC Contract number 1? Jaine, would you take this one, please?
Sure. There's a number of differences between using GAFTA 125 and GAFTA 126. GAFTA 125 is a two-tier dispute resolution process, whereas 126 is only one stage. Using Rule 125, each party has the ability to nominate an arbitrator, and then GAFTA appoints the third to become the chair. It's important to remember that although you can nominate an arbitrator, this isn't your arbitrator. They don't act for you. Once you have appointed them, they then become part of a neutral panel of 3. With Rule 126, there is only one arbitrator appointed, and this arbitrator is appointed by GAFTA. Should, however, either party be unhappy with the arbitrator that's selected, either under 125 or 126, there is the ability to appeal to GAFTA to have the nomination reconsidered. In terms of the awards that are actually produced, under Rule 125, you'll get a fully reasoned award, and then you can actually appeal again under GAFTA. And average costs and prices, so average cost for Rule 125 for the production of an award is about 9 months, and the average fee is about $12,500. Under Rule 126, it generally takes about 3 months because it's a short one-stage process. And again, the average fee is about $7,700. I should also say that because of the fact that people tend to explicitly contract under 125 or 126, if we do get arbitration claims that come in under 125, and they're obviously for a very small quantity of goods, we will write to both parties and invite them to consider whether they want to use 126 instead.
Thank you. Jaine, I'd also ask you to pick this one up. If there are a series of contracts between two parties and one party defaults, does it allow the other party to suspend performance of the other open contracts?
No, it doesn't. And this is because under English law, the contracts are considered to stand on their own. So defaulting under one contract doesn't give you the right to automatically cancel the other contracts. What we do, though, is allow people to potentially consolidate awards if they have several contracts that they have a dispute with. And also, when we revised the 125 rules recently, we made it more explicit that the arbitrators also have the power to consolidate hearings as well if they feel that it's in the best interests.
And are GAFTA awards of arbitration enforceable?
Yes. GAFTA GAFTA awards of arbitration are enforceable. In the vast majority of cases, when you're handed down a GAFTA award, the other party pays it. They might not be very happy, but they will pay it. If the party doesn't pay it, then GAFTA will actually write to the defaulting party and encourage them to pay up. If they don't, then we will place them on what's called the GAFTA defaulters list, and we will notify all GAFTA members that this particular party has not complied with an award of arbitration. And that's generally fairly effective at preventing people from, failing to uphold their awards. And every year we get several people who've been on the GAFTA defaulters list who pay up. The other way that GAFTA awards are enforceable is in the local courts under the UN Convention, what's called the New York Convention on the Enforcement of Foreign Arbitral Awards. There is a list of countries who are signatory to those awards, and so if you take your GAFTA award to the local court that's local to the defaulting party, you can ask them to actually enforce the award.
Although you've covered part of this, I'd like you to take us through on a step-by-step basis what a claimant should do to recover their losses.
Document them, I think, is probably one of the most important things. And to remember that losses which flow directly and consequently from a breach can generally be recovered, but you will need to evidence them. There is also a duty to mitigate, so you can't, for example, decide not to take any reasonable steps and simply allow a demurrage claim to escalate or goods to continue to take up storage room and increasing costs. So as long as you take reasonable steps and you can document it, you can present these costs to the arbitrators, and then they will consider those and make an award to actually include those costs as well.
Could you run through the step-by-step as per the slides of from having a dispute going through the arbitration process?
Well, first of all, you've got to apply for GAFTA arbitration, which means you've got to make your claim within the time limit, which is generally 1 year. You've then got to submit to GAFTA a fully documented claim showing the terms on which your contract was concluded, whether this is GPC Contract number 1 under GAFTA 126 or perhaps GAFTA 88 under 125. You'll need to pay a deposit for arbitration fees at this particular point. We'll then notify the claimants and they will need to settle any fees over and above the deposit for the award to actually be released to both parties. Very often, the total cost of a GAFTA arbitration is actually less than the deposit. So in those cases, we will actually refund any fees and give you the arbitration award. GAFTA's arbitration awards are confidential. They are only shared between GAFTA and the parties. We do not even share them widely with arbitrators for training purposes, so they are a confidential document. The respondent will be, as I mentioned before, will be asked to actually settle the claim, and if they don't, this is when the GAFTA defaulter process will actually take place.
I think another point to mention is that interest costs are generally recoverable, but legal fees are generally not recoverable.
That's correct, unless the parties have agreed otherwise, which is not generally the case. And I think another thing that's also worth bearing in mind is that loss of profit on a subsale contract is generally not recoverable unless there are particular circumstances, such as the other party being aware of the importance of the subsale at the time the contract was entered into.
Okay, now to Huseyin. What disciplinary actions can we at GPC take to help recover losses from a defaulting party?
Yeah, thank you, Andrew. First of all, when this result came out, what we do, our committee approaches to the party for the payment of the award. If they don't make the payment of the award, and then what we do, the committee will inform our GPC executives, committee. So what we are going to do in executive committee, we have a chance to make a disciplinary action. What kind of disciplinary actions we are taking? First of all, they are going to be barred entering any GPC events. And GPC has more free hand than GAFTA. We can publicly announce these companies to our members and all associated national associations. And all these members are going to be, all these people are going to be banned any event of the associated members, like Pulse Canada and whatever our associate members are. So they will not be able to enter into any of the events and functions of these organizations. And furthermore, I think what we did is that at executive committee, we are also taking seriously that if a buyer or seller repeatedly doing these things, even if forms a different company, we will bar this company from entering any functions and event of GPC and our associated members.
Thank you. We are running short of time, and I wanted to give opportunities for questions. I don't know if we've got any coming up through the app.
We have questions on board.
Okay.
The one most like is 3. Can you read it, or if you want, I can read it to you.
Yeah, I can read it. So on the first question about analysis, which doesn't comply with the standards of the importing countries, it's important that the buyer, when they are establishing the contract, puts in the contract specifications that they want. It is not reasonable to put on the seller to know what are the requirements of the importing country. So if there was a dispute and it came to arbitration, the arbitrators would look at the specifications agreed between the two parties and require that rules as to what is right or wrong. There is not an assumption that a seller can be aware of all of the regulations in the importing country. Jaine, would you like to comment on that?
No, I was waiting for the other.
Okay. Okay. Jaine will do one of the other questions. Which one?
It disappeared. You replied, it has disappeared.
Looking at, I think there's probably 3 that relate to GAFTA. If first one, if the buyer defaults goods on port, when we start the claim, how long will it take to get any solution? Well, if you're using 126, you will generally get an award within 3 months of making the claim. If you're using GAFTA 125, it's generally going to be about 9 months. And again, it's incumbent on you to try and mitigate your losses as far as you can, but any reasonable losses associated with the default, which are caused by the defaulting party, will be taken account of in arbitration.
So, I mean, here is the timeline. What the question wants is actually, you will find you have to sell it somewhere else, or you leave on the dock because it is not sold. Even if you sell somewhere else, you can prove that it is default.
Yes.
So after certainly you feel that it is default happened, then you can start GAFTA process.
The second one, the average cost to apply, sorry, it's gone again. Sorry, the average cost for us to apply to GAFTA for a claim. When you initially claim arbitration with GAFTA, you don't actually have to pay anything at all. And it's advisable for you to do so as soon as possible to protect your position and to make sure that you're within the time limit for the claim, which is generally 1 year. It's only when the proceedings, you're ready to actually take those proceedings forward and sort of issue your formal claim that we will ask for a deposit. I mentioned before that 125 costs on average about $7,700. The average cost for a GAFTA 125 claim is about $12,500.
Regarding the question of when must the seller request an extension of shipment, it's covered in GPC Contract number 1 under clause 6, which I'll read. It says, sellers shall serve notice claiming extension not later than the next business day following the last day of the originally stipulated period. So let's try and simplify that. If you had sold May shipment, then latest 1st of June, you would need to apply for an extension of shipment period if you required it.
The next one around, does the claimant have to be a GAFTA member to claim arbitration? No, they don't. And we regularly get arbitrations that feature both parties as non-GAFTA members. If, however, you are a non-member, you'll have to pay a non-member's fee, so it will cost you more. Something else to actually bear in mind, it's very rare for a GAFTA member to default on an award of arbitration. And a little bit like some of the disciplinary regulations that Huseyin was referring to, one of the options that we have at GAFTA is to actually terminate the membership of somebody if they do default on an award of arbitration. So in terms of your sort of know your counterparty pre-contracting advice, you would be well advised to look to see whether the other party is a GAFTA member or not.
Again, trying to get some quick answers in. On the question about a shipment advice needs to be tendered within 5 days of bill of lading date. Do we mean shipped on board or just the BL issue date? Decision was made with GPC contract number 1 that it would always be based on board bill of lading date, although if both parties agreed, they could still use receive for shipment bill of lading dates when the cargo is handed over to the container consortia, but without agreement otherwise, it would be the on-board bill of lading date. Now, the sign is showing out of time. We've got more questions. Are we out of time? Where's our Master of Ceremonies? Are we out of time? Okay, so we'll have to leave it there, but we'll be able to respond to the questions that were raised separately. So if there are other burning questions you've got, come and seek out Jaine or Huseyin or myself.
Yeah, I want to reply one question here because I don't know who wrote it. Half is in Turkish, half is in English. It says hükümet reddederse. Who wrote this? He was very... Anyway, thank you. This is no different than, this clause is no different than the reply we gave at the beginning, that government restrictions or government problem is your problem. It's not seller problem. Okay, we have time.
So let's try and get some more answers. Mostly defaulters are non-GPC members. During application for GPC membership, you better ask to bring letter from their local trade association. Huseyin, do you want to comment on that?
I don't know what the question wants to say. He wants to, this anonymous friend wants to give a message on between the line, but I don't understand the message. Mostly defaulters are non-GPC members. Is it? I don't know. During application for GPC membership, you better ask to bring letter from their local trade association. Like from Turkey, if they have incorporated, they have always, they have to register with the government, like Exporters Union. So they can bring, any company can bring a letter from that. And maybe in India, if IPGA doesn't give the letter, but I don't know. This is good to think about it.
Yeah, I agree. It's something that we haven't yet faced up to, but I would like to suggest that if there was a new member of GPC and you had an unsatisfied award of arbitration that hadn't been settled, if you notify the GPC Contracts Committee, then we would take that to the executive, and we're looking for people as members of GPC to treat others as they themselves would be treated. So if there is an unsatisfied award of arbitration, I would imagine the GPC executive would like to involve itself in trying to resolve that situation or rescind membership.
Yeah, we will.
But we're making up policy as we go along.
Yeah, there is one. Which question you take?
I was just going to say something about the quality certificate. So you've got a quality certificate from an independent surveyor, hopefully a GAFTA approved one, and then your cargo arrives and it's damaged, it doesn't match the certificate, what can you do? Well, I'm going to make the assumption that you've shipped on certificate final, which tends to be the majority of cases these days. In this case, it's unlikely that you could challenge the certificate final, but you'd probably want to do some tests to try and find out what kind of water damage it was. Was it, fresh water? Could it have been that the hatches were left open during loading? Is it salt water? Is it damage that could have occurred during the journey? And so you'd probably then be looking to make some sort of either an insurance claim or a claim against the carrier.
Yeah, I mean, here we should add one thing, Andrew, that the definitions, we have definition problem in our industry. So to overcome this, we are talking to the Canadian government and their bodies about to have the same language on same definition. The question that here is reflecting the definition differences between different origins. So it is one of our tasks as a Global Pulse Confederation to talk all these government people and to bring into a standard definitions, at least the meaning of the word and definition of the word, we should be talking of same thing. Otherwise, there is going to happen a chaos, and it happened a chaos a year ago from the shipments from Canada. Like for Canadian standard doesn't show wrinkle, practically you can load 100% wrinkle and get US Canadian #1 certificate. And this wasn't fair. We raised this our objection in Canada, in Vancouver. They formed a committee, and this committee, I tell you, still working, because last week they approached me. On Tuesday, we will have conference call with these people to sort it out from the Canadian side.
Moving on to the question about if one of the parties is unwilling to participate in the process of dispute resolution, what happens? GAFTA principles have been that both the claimant and the respondent have an opportunity to put forward their case. But if one party refuses to participate, then the arbitrators will proceed on the basis of the facts that are in front of them. So if there is a default, a market-inspired default, and the buyer just ignores the whole process, the arbitration can still proceed. Jaine, would you like to add anything?
Yes, I mean, this does happen from time to time, and in those cases, GAFTA will actually appoint an arbitrator to act to represent the party that isn't participating, so that we would still have the panel of 3 or the sole arbitrator in the case of 126. But it doesn't affect the validity of the process. Even if the other party takes no part within the process, you will still end up with a GAFTA award that can be enforced.
On the question of do we have to engage lawyers at high costs to prepare an arbitration claim, the answer to that is definitely not. We should try to avoid bringing lawyers into this process. The idea behind arbitration is you've got trade specialists, not lawyers, who act as arbitrators, and that you should state your case simply, concisely, and clearly. My strong advice would be to avoid going to lawyers. In fact, under GAFTA contract number 126, it stipulates that the presentation of a claim should not be done by an advocate, a legal professional, because the concept is that it's the trade experts who will help resolve this. We only go to a court of law to try and enforce payment of an arbitration award if the other party declines to settle. Jaine, would you like to add something on that? Okay. Yeah. Sure.
There was a couple of questions. One around how do you apply to GAFTA to claim arbitration? And in order to start arbitration, it's a very simple procedure. You need to first of all serve notice on your counterparty, and that can be simply by email, that you intend to claim arbitration at GAFTA. Again, the second step is you then contact GAFTA's arbitration department, again, usually by email, saying that you want to claim arbitration. And at that point, as I said before, you don't actually have to pay any money, and you've secured the opportunity to then decide how to progress with your claim, or potentially even negotiate with your counterparty for the year's time limit. So counterparty first, then GAFTA. The second one, the seller liable to pay any justifiable claim, is market loss in buyer classified as a justifiable claim. As I mentioned before, in general, you cannot claim loss of profit on a subsale within GAFTA arbitration unless there are very specific circumstances. And that generally means that your counterparty, your buyer, knew that you were absolutely reliant on this sale, perhaps in order to perform some other kind of contract. But you would need to be able to evidence this. But as a general rule, no.
I'd like to pick up on that. The concept would be if there was a default and the buyer didn't take up the documents, then the seller has to prove what the market value is for those goods in that position at the time. So, for example, if you had bought something old crop at old crop price levels, and new crop, which would be shipment 2 or 3 months later, were at lower levels, if there was a default, the seller would have to look at what the market price for the goods is in the location where the goods are at the time, and it wouldn't be acceptable to arbitrators to come up with a price for goods that wouldn't be available for 3 months further. I'd like to pick up on the question about documentary delay due to bank fault. The banks have got a responsibility to turn documents around in a reasonable time, and then it depends whose bank has made the delay. If the bank is the buyer's bank, that the buyer said, please present the documents to me through bank ABC, therefore they are the buyer's bank, then it would be up to the buyer to recover any extra demurrage because of the bank's failure to process the documents speedily. If it was the seller's bank, that the seller has chosen the bank to present the documents, then it would be up to the seller to approach the bank to make good demurrage charges because they hadn't processed the documents with all due haste. Okay, on the question of a letter of credit extension, what can be done to force an amendment to the letter of credit with the suitable 8-day extension? Effectively, there is nothing the seller or GAFTA or GPC can do if the LC is not extended, but it would nevertheless be a default by the buyer, because if they'd agreed to trade on the basis of GPC contract number 1, which allows 8 days extension, if they don't effectively make that extension available by extending the LC, they will be in default. And a way to get around that would be to build in those extra potential 8 days in the shipment period when the LC is first open. So if you've sold June shipment, you should look for shipment up to the 8th of July to be tenderable under the letter of credit with a suitable expiry date.
There are a couple of questions about GAFTA and other countries. The first one was around what about countries who don't know anything about GAFTA, don't have an agreement with them, what can you do? Well, we're always very keen to hear about countries where you think GAFTA should go, to run seminars, to run courses, to raise awareness of GAFTA and how it works. We don't have specific agreements with countries, but I think the point that was made before about checking whether or not your counterparty is in a country which has signed up to the New York Convention is really important, because if you contract with somebody who's based in a country that has not signed up to the New York Convention on the enforcement of foreign arbitral awards, in the event of a default, you may find it hard to actually enforce that award. The second question was around GAFTA's offices around the world. We're headquartered in London, but we also have offices in Geneva, Kiev, Beijing and Singapore, and members in 90 countries around the world. And we do try to travel as much as we can to have the opportunity to meet with members and non-members. In terms of arbitration, if it were to go to an oral hearing, and remember 125 and most 126 cases will be dealt with on documents only, in other words by email, so there'll be no requirement to travel. It's generally only at appeals under 125 where there's an oral hearing, and although most of them do take place in London, the reality is they can happen anywhere in the world as long as both parties agree. And one of the things at GAFTA that we're trying to do, particularly with running our training courses all around the world, is to encourage more, particularly younger people, to train to become arbitrators in different parts of the world so that we are able to offer more locally based arbitration.
The question with 4 likes, where is reanalysis to be done, in the country of shipment or the country of arrival? Generally, if you're talking about reanalysis or regrading, it would mean that both buyers and sellers have jointly drawn samples of the delivered cargo, and then they would be resubmitted to whoever issued the original certificate of quality. If the contract referred to a grade, for example, US grade number 1 or Canadian grade number 1, then it would need to go back to the relevant authority in USA or Canada to do the regrading. It wouldn't be possible, let's say for a European buyer, to do the analysis of a sample to say whether it's US number 1 or Canada number 1. That would have to be done in origin. Do either of you want to add anything on that?
In the case of a default in arbitration, what is the role / liability of a broker?
Jaine,
well, obviously, it depends.
Jaine, moment, please.
Sorry.
Because the president of Sri Lanka is coming, I have to get and take him here. So you continue without me. Actually, you don't need me here anyway. But the questions was perfect, so I am leaving, and I will come hopefully with the president of Sri Lanka.
That's great. Thank you, Huseyin.
Thank you.
So just briefly to return to the role and liability of the broker, it depends on what the nature of the default and arbitration case is. If it is, for example, regarding whether notice was validly served and the notice was actually served on the broker, then that is good notice. So actually the broker may well be involved. However, there may well be arbitration disputes that actually have nothing to do with the role of the broker.
Also, I'd like to add that the broker has actually fulfilled their service by introducing the buyer and the seller and agreeing the terms of the contract, and their brokerage is payable whether or not the contract is fulfilled. I received a question, do we have to pay the brokerage before we ourselves have been paid? The answer to that strictly is that the brokerage needs to be paid, as I said, whether the contract is fulfilled or unfulfilled. Personally, during my career in the industry, I've waited until the buyer's paid me before I settle a broker's commission. But I'm probably stepping a little bit over the mark. We're out of time. Thank you very much for your interest, and thank you to Jaine for lending us your expertise. Thank you.